because of some very good news from the Supreme Court. The Supreme Court's been getting a lot of attention lately in the news because of another ruling, the Dobbs ruling. I want to look at it strictly from the point of view of governance. And I'll say the same thing tonight, like that, what we're presenting isn't to take a side, one side or the other on the material interest of the parties of the case, but to look at the law and what the Supreme Court, their ruling, what it means for us and we the people. We at the Commoner Law Group are here to support you and support Americans in learning and practicing the basic principles and practices of law such that you can manage your own personal affairs, and that we collectively, the collective sovereigns of this land, can also have the form of government that was created a few hundred years ago and was gifted to us, and it's our responsibility to appreciate that gift and keep it alive. But you'll see that there's quite a bit of controversy about the very form of government that we have in the first place here in the 21st century. So again, welcome everybody. Thanks for being here. I really do appreciate everyone's interest in the topic. Energy should be celebratory. There's so many times where we get together in our different courses and special discussions, and we're kind of bemoaning the situation, the encroachment and infringement of our natural rights. And it's not something new. It's been happening for a long time, but it's been rare to be able to celebrate, particularly with the pandemic. But guess what? The Supreme Court seems to be doing its job. So I'm going to assume, for the sake of this presentation, that everyone understands the basic idea of separation of powers, that the founders of our constitutional republic determined that tyrants always try to consolidate all three aspects of government, which are the legislative or rule-making aspect, the executive element, which is to execute the law that was created by the legislature, and then the judicial element, which is there to make sure everything's just and that everyone's playing by the rules. In a kingdom, for example, all three of those powers are held by one person. In a dictatorship, all of those three powers are held by one person or a very small group of people. And yes, absolutely, there's a very good argument to be made that we in the United States are actually under that form of government as well, not because that's what was written down in the Constitution, but that's what has over time slowly happened, like incrementally, slippery slope kind of stuff. And so we find ourselves at a very late stage of governance where the three different elements I just mentioned have gotten consolidated in many, many ways. So let's jump into it. We are going to take a look at this most recent Supreme Court ruling in West Virginia versus the EPA. This is in fact a summary provided to us by the Supreme Court itself for the recent ruling, and it describes not only the case and the ins and outs of the arguments on both sides, it gives the ruling itself, and then it has a number of opinions by those on the side of the ruling and those on the dissenting side who didn't agree with the ruling in terms of the members of the court. But we're going to start out with some history, because really to understand the importance of this case today, we need to have a very rich and full understanding of what has happened in the last 140 years, beginning with what many people call the modern era or the progressive era. You see in the late 19th century, the very late 19th century, technology and industry had become so efficient, had really made such great strides that it changed society. It changed our norms. It changed so much about America. We had previously been an primarily agrarian nation. And because of so much technology and efficiency gained, productivity increased, the standard of living was increasing, and people were moving to the cities, and factories were becoming places that attracted laborers from the country, and they would work in factories. And we entered the modern era where science really reigns, chemistry and technology and engineering took over. Of course, there's much to say about the fruits of technology and science for so long, for so many years now. And we're living in a very rich and comfortable time for the most part. But you see, at that time, back in 1890, 1900, the ideas of socialism started to take hold because of the shift in the makeup, the demographics of our nation. And it wasn't just happening in the United States, it's happening in other developing nations as well. But the idea that individual rights were sacrosanct started to be questioned, and the idea that what's better for the whole started to become more popular. And so I want to take you to an understanding of this phenomenon from a course that I highly recommend you all take. It's a free course on the Constitution called Constitution 101 at Hillsdale College. So you can just go to Hillsdale College's website and click on courses. It's a free course. You sign up with your email, and it's a wonderful, wonderful course. I highly recommend it. Only the parts about the Civil War would I have some questions, but otherwise it's very good. In particular, this one lesson on the progressive era. So,
but just to start with the basics, kind of a general point at first, I like to think of it as an argument to progress or to move beyond the principles of the American founding and the original structure of American government. And it's an argument to enlarge, to greatly enlarge the scope of our national government for the purpose, the progressives argued, for the purpose of responding to a set of circumstances, of historical developments that could not have been envisioned by the framers. The framers came up with a set of principles and a set of institutions that responded to particular circumstances. The circumstances are no longer with us. Therefore, we don't need the principles of government that were constituted to deal with those circumstances. Now, the founders, as we learned earlier in the course, they had a sort of permanent understanding of just government. When they talk about just government in the Declaration of Independence, what Jefferson means by that is not just government right then and there. He's talking about an understanding of government that transcends time. This basic government of securing natural rights, of being based on consent of the governed, that's not just government for the North Americans in the late 18th century. That's just government for all human beings by virtue of their human nature and their God-given rights. So they've got this permanent understanding. The progressives, by contrast, want to say that the ends of government, the scope of government, that's going to change. That's contingent. That's relative. That's going to depend upon the new circumstances of new times. And so they've got this perspective of what I like to call historical contingency, right? Meaning, if you ask the question, what should government be? The answer to that question is contingent on the circumstances. You're going to get a different answer in 1787 than you'd get in 1900.
So I'm sure that resonates with you. The first thing that comes to my mind when I hear that is the debate lately about gun control. And so many people say, there weren't the kinds of guns the kinds of armaments that we have today, these highly sophisticated rifles, et cetera, that did not exist when the Constitution was written. And therefore, we can't honor the Second Amendment, can't treat it the way that they treated it so many years ago. We have to be more pragmatic and be aware of the times and use government in a different way. But I'm sure you can think of many, many examples of that. But let me just give you one more bit from the same lesson on the progressive era from Constitution 101 at Hillsdale College.
He says, let's talk about what socialism is. How does socialism view the relationship between the individual and the state? He says, socialism proposes that all idea of a limitation of public authority by individual rights be put out of view, and that the state consider itself bound to stop only at what is unwise or futile in its universal superintendence alike of individual and of public interest. The thesis of the state socialist is that no line can be drawn between private and public affairs which the state may not cross at will. Right? So the power of the state trumps the rights of the individual. And Wilson says, now, that's pretty close to how we progressives view democracy. He says, in fundamental theory, socialism and democracy are almost, if not quite, one and the same. Well, why are they one and the same?
That's a good question. Why are they one and the same? But it's really time for us all to be honest about these terms. Socialism came about as well in the late 19th century as a response to this modern era where people were moving into towns or factories. The way I like to put it is, it's one thing to own a factory and another thing entirely to work in a factory. And that was the kind of division that you were seeing. And we're kind of living in it today, where you have a hierarchy of oligarchs who own an enormous amount of the means of production and just material goods and property and everything in the United States. And then there's so many just workers. That's not exactly the way Americans like to think of themselves. We like to think of ourselves having a healthy middle class, and that we have a lot of freedoms, and there's opportunities to climb the social ladder in terms of your wealth. Just on your gumption and your ingenuity, you should be able to become wealthy, and just like everyone else. The American dream, isn't it? Well, the progressives and other central planners in Washington, D.C., and other capitals of the world have been working really hard to create a top-down control mechanism that doesn't allow for much sovereignty for the individual. That means individual, like human beings, like you and me, as well as individual enterprises. This presentation by a professor at Hillsdale College is very interesting in just laying out the basic historical nature of it. But I'm going to play for you now a clip from a video that is one of my favorites, someone named Murray Rothbard, and this comes from the 80s. And he's describing that there's more to it than what meets the eye. So I'll just play a little bit here, and you can take it for what it's worth.
Basically what happened was, in the progressive period, by the end of the 19th century, business, first of all, was extremely competitive all during the late 19th century. This is as a broad generalization. And prices were falling throughout. In other words, from the Civil War down to about 1900, late 1890s, prices were generally falling. And they were falling for good reason, namely that business was so competitive and the economy was so productive that the supply of goods and services was increasing at a rapid rate. In other words, that's when America industrialized. It was the biggest period of economic growth in the history of the world. And standard of living went up, and productivity went up, and prices fell. This did not mean that businesses were suffering, because costs were also falling as the productivity increased and mass production increased. So in this situation, the many business groups who tended to be inefficient try to correct this price falling situation by organizing cartels. In other words, by organizing a cartel of each industry so that they could cut production and raise prices. And this was tried in industry after industry, starting with the railroads, which were the first big business in the United States, first large-scale business, and continuing on through manufacturing by the late 1890s. Either trying through cartels, formal cartels, or through mergers. And in the late 1890s, the theory was, we'll just merge into we'll have one big firm for the entire steel industry, the oil industry, et cetera, and then we'll be able to cut production and raise prices and raise profits at the same time. So they tried this systematically. This was the ideology, so to speak, among businessmen, that the way to benefit for all of us is to have quotas, either formal quotas as in cartels or in mergers, where you just agree that you will have certain shares of this corporation, and then we'll cut production and raise prices. That was the great goal. All of this was a total flopperoo, and case after case, literally hundreds of cases of this kind of merger or cartel, they all flopped. And they flopped for two basic reasons. One is that an economic theory can predict this, and this is confirmed time and time again. Two basic reasons. One is, the basic reason is that the industry is free. Government did not step in and force people to accept the cartel or accept the merger. So what happens is that as soon as the cartel is formed or the merger is completed, and and then they cut production, raise prices, and profits go up. Other businessmen come in and say, "Hey, this looks like a great industry here. The zinc and whatever, the zinc industry or the oil industry or whatever, railroads. They're making a lot of profits. Let's nip in there and outcompete them because they're raising prices. And we're going to now come in with a new firm, a new factory, a new railroad, and we'll bust them." And that's exactly what happened. So you had new competition always coming in and outcompeting the older firms, and then the older firms are stuck with a new firm. Then you have a permanent competitor, which is a big pain in the neck because they come in with later equipment, with new factories and new equipment, the latest technology, et cetera. And now they have a permanent new competitor on their hands. So the whole thing became a big pain in the neck for them. And that's one reason. And then internally, what happened was that individual firms would start breaking in the cartel. They say, look, we've raised, in other words, the cartel restricts production, raises prices are very high. And then the individual firm says, look, I'm not supposed to do this because I have a cartel agreement with the rest of my buddies in the industry. But here's what we're going to do. For you, my old pal and drinking buddy or whatever, my buyer, I will sell you the steel or the whatever, titanium, et cetera, for 20% off list, provided you don't tell anybody about it. Okay. So what you have is a secret price cutting. And then this firm gains profits, gains sales, and of course the secret leaks out pretty quickly after about 6 months or a year. And then the other firms get very mad about this, and they call you your rate buster, which is in business terms is equivalent to scab in union terms. And the whole cartel falls apart with mutual recrimination and hatred, and they're back where they started, except now they've got more hatred than they had before.
So yeah, I wanted you to hear some history and start to understand that there's more than meets the eye in terms of the way Washington, D.C. operates. According to Murray Rothbard, these cartels failed for the reasons he just explained, and the only way to prevent that is to hire government to enforce those cartels, their price fixing, but to do it in a way that looks like they're doing something good for we the people. So in the progressive era, which is arguably, one could say, from the turn of the century, 1900, to say through FDR's presidency, and that throughout those many, many years, that's when you saw the institution and the creation of many, many federal agencies that were created to protect Americans, just as in the name Environmental Protection Agency. And what we can see, if you do an objective analysis, these agencies don't really do what we think they do. If you just follow their policies over these many, many, many decades, it seems very clear that what they do is they make rules that help the cartels stay the cartels, that is the small group of industries working together to dominate a particular industrial sector, like telecommunications today, or internet search engine, or social media, but also, of course, as the old oil, petroleum, energy production, which is relevant to our discussion. And in so doing, for others who want to come in and try to compete, it makes it hard for them to do so, and yet it keeps the cartels playing well with themselves so they don't break apart. And it's been working very well for a very long time. It's quite the formula. So when you hear terms like the administrative state, or the deep state, or the permanent bureaucracy, or even very popularly now, the swamp. Drain the swamp, I think I first heard it, I don't know, maybe back in the 80s. Just so happens that Washington, D.C. is very much a lowland area, like a swampland. When it was first built, it was reclaimed swamplands. But the idea is that the swamp is flooded now with federal agencies, many, many federal agencies that are captured by industry. And this does not serve we the people at all. So I'm going to show you, in fact, just so it's not conceptual, what our swamp looks like in real terms. Take a look at this. Okay, this is from Wikipedia. It's a list of federal agencies in the United States. We aren't even going to be able to count them, but we're just going to, as fast as I can, try to move through them so you get a sense of the enormity. All these agencies were created in the last 100, 110 years. The EPA, in fact, was only created in the 70s. We just want to be familiar with all of these. Just take a look at these agencies. Here we go. I mean, you're familiar with some of these. Some of these you'll be familiar with. Others you'll never have heard of before. But you've got United States Department of Agriculture, and then here are all the agencies underneath the Department of Agriculture. Okay. Then you have the Department of Commerce with how many agencies? Here, Department of Commerce. Look at all these lists and names of agencies. The Department of Defense is enormous. It includes, of course, the Army and the Navy and the Air Force, which has its new Space Force. Department of Air Force has the U.S. Space Force as part of it. So it just grows and grows and grows. You have the Department of Education, right? Very important in terms of educating we the people. Who do we let educate us? But see, there's plenty of money and lots of agencies who are dominating the field of education in America. You have the Department of Energy as well, energy being critical to all aspects of life. And here are the many agencies involved in regulating everything to do with energy in the United States. There's the Department of Homeland Security, I think the newest among the cabinet positions. We talked about that in our Real ID discussion. But here we go. Look at all these agencies under this new one. You have the Department of Housing and Urban Development, okay? Looks like they have, by comparison, fewer agencies by name, but the amount of money that goes through HUD, called HUD for short, is enormous. Some say it's the largest money laundering outfit in the world, but that's for another day. And then you have the Department of Interior. So that had the Bureau of Land Management, Park Services, you're familiar with, are included in that. Department of Justice, they're enormous. This is the FBI, Interpol, showing here. Department of Justice was the ones who came out with their judicial analysis of the legality of vaccine mandates, and they concluded that vaccine mandates were not illegal. The United States Department of Labor, so that's huge, right? The Department of State deals with the United States' relationship with the rest of the world. So many agencies, so many agencies. And then we get to the Department of Transportation, Department of Treasury. I hope not to bore you, but this is really the swamp. Imagine the water just rising and rising as I go through this. Veteran Affairs. Now, on top of all the cabinet level within the executive branch, you have independent agencies that are not associated with the cabinet positions within the executive. Their legislative authority is a mixed bag, but you have, again, a huge number of independent agencies that in some cases have commissions that are their governing board. Sometimes there's an individual that's appointed. These are all created through legislation. We, the people, are not being represented because it's our own legislators in Washington, D.C., it's Congress that has been creating this administrative monster, this deep state that keeps getting deeper and deeper. Look at all of these agencies, independent agencies that have executive power. They're not supposed to make rules themselves, but see, in the modern era, the idea goes that even our congressmen and women, as smart or educated as they might be, cannot be expected to understand all of the information about this extremely technological era in which we find ourselves. How could you, in one session, be debating about space flight, and then the next minute debating about nutritional programs for kids in schools, and then the next day about what to do with nuclear waste? And there's just so much technological knowledge that a person needs to know in order to make decisions. So the idea goes that, first of all, we the people can't be expected to know all those things, and our representatives can't be expected to know all those things too. So what they do is they create legislation to give it over to the experts. We're going to create an agency, we're going to fill it full of all the scientists and experts, and then they're going to tell us what to do because they're the smart ones and they understand all of the intricate details. And they make up everything, like within construction, the size of bolts and the weight bearing, just every single detail of construction in factory. In this presentation, it's about emissions from coal burning and natural gas burning energy power plants. These specialty agencies are on top of all the other agencies that come under the cabinet of the United States. And what I want to do is I want to show you that some of these independent agencies somehow are not like all the others in the sense that they have been given honorary cabinet position. So when you go to the White House's website, I also want to show you this because I like to put faces and names. And even though it seems like a monster and all of these agency names have all these bureaucratic sounding names, and it's probably a full-time job creating names for agencies to make them sound really good and efficient and that there's something worth financing and creating. But here we have the vice president's part of the cabinet, secretary of state, the secretary of the treasury. So we mentioned these cabinet positions a minute ago. Secretary of Defense, you recognize Janet Yellen. She used to be on the Federal Reserve Board, which is one of the independent agencies. Merrick Garland, Attorney General, that's Department of Justice. You have the Secretary of the Interior, Secretary of Agriculture, Secretary of Commerce, the Secretary of Labor. Here's the Secretary of Health and Human Services, which includes the CDC, the famous Centers for Disease Control and Prevention, which we featured in our presentation a month ago about a court ruling that put down the CDC's transportation mask mandate based on some similar principles that we're going to be discussing in terms of the ruling. You've got the Secretary of Housing and Urban Development, you've got Secretary of Treasury, Secretary of Energy, Education, Veteran Affairs, Homeland Security. Remember, these are all cabinet level positions, but then all of a sudden you hear of the Administrator of the Environmental Protection Agency. So we have all those countless and so many agencies, but somehow the EPA, a new kid on the block, started in 1970. But here, the administrator of the Environmental Protection Agency is included in the White House's cabinet. You've also got the Director of National Intelligence, another independent agency, the U.S. Trade Representative, Ambassador to the United Nations in the White House cabinet, Chair of the Council of Economic Advisors, Small Business Administration, another independent agency, Offices of Management and Budget, and the Chief of Staff. So there's your cabinet. Included in that's the EPA. And just notice the EPA from its logo, its name, environmental protection, and its marketing here, smiling kids, everything's happy, green. It's obviously completely dedicated to making life better for we the people, right? That's the lie. That is the fraud. This swamp, this administrative state now exists mostly to keep itself alive, an enormous workforce. And I assert when they go to work every day, their number one priority is to keep their jobs and keep their pensions. And what their overall function is, again, you can take it from Murray Rothbard that they're there to make sure that the cartels maintain their dominance or whatever you like. But real quick, here's their legal authority, okay? So the Environmental Protection Agency can only act pursuant to statutes. The laws passed by Congress, okay? That's exactly where the Supreme Court ruled that they were not doing that. That's basically the bottom line, the short answer, that they had exceeded their statutory authority. And the appropriations statutes authorize how much money the agency can spend each year to carry out the approved statutes. The agency has the power to issue regulations. Now, a regulation, is that a statute? No. Is that a code? No. It's a regulation that they write based on direction given to them by the statutes. A regulation interprets a statute, and EPA applies its regulations to various environmental situations and enforces the requirements. So they write the rules and they enforce the rules. So the agency must include a rationale of why a regulation is needed, and that needs apparently to be tested in the highest court of our land, the Supreme Court. Regulations can be challenged in federal courts, either district court, appellate court, or depending on the particular statutory provision, now the Supreme Court. So West Virginia versus the Environmental Protection Agency, it's actually, there's many other plaintiffs. I'll show you. To make it briefer to describe it, it's just called the West Virginia et al. Versus Environmental Protection Agency et al. But you notice it's a certiorari, and that I just want to quickly define for you all. In law, certiorari is a court process to seek judicial review of a decision of a lower court or government agency. It comes from the name of an English prerogative writ issued by a superior court to direct that the record of the lower court be sent to the superior court for review. The term is Latin for to be made certain, and comes from the opening line of such writs, which traditionally began with the Latin words certiorari volumus. We wish to make certain. Derived from the English common law, certiorari is prevalent in countries utilizing or influenced by common law. It has evolved in the legal system of each nation as court decisions and statutory amendments are made. In modern law, certiorari is recognized in many jurisdictions, including England and Wales, Canada, Ireland, India, the Philippines, the United States. With the expansion of the administrative law, right? We're talking about this whole administrative state, administrative law, and the expansion of the administrative law, the enormous number of agencies promulgating millions of lines of regulations that have, the swamp has risen and risen. We're drowning in regulations. In the 19th and 20th centuries, the writ of certiorari has gained broader use in many countries to review the decisions of these administrative bodies as well as lower courts. So what's important about this is that the Supreme Court is actually doing its job. It hasn't been doing it for decades. So let's get into it, okay? The whole thing revolves around the Environmental Protection Agency's promulgation of what's called the Clean Power Rule. And the Clean Power Rule is different than other rules in a lot of ways. And this is where the court is trying to point out to us that they really overstepped their bounds in a big way. But it comes from this Section 11 of the Clean Air Act, which I'll just show you real quick here. The Clean Air Act, this is a US code. This was passed by legislature, by majority of our Congress, and signed into law by the executive. And so this has all of the definitions of what it is to create standards. This is all dedicated to the ability, particularly Section D was in question, the ability of the EPA to regulate standards of pollution emissions from coal and natural gas fueled energy plants. They have been doing that for years. And for the most part, they had been regulating what we had thought of as pollutants, sulfuric acid being one of them. That's a natural product when you burn coal. They've had to capture it and not let it go out in the air. And the EPA has been successful in regulating that in a very big way. Here it is. The Clean Power Act established emission guidelines for states to follow in limiting carbon dioxide emissions from existing power plants. So today, carbon dioxide is now considered a pollutant. For many, many years, it was considered carbon dioxide, and now it is considered a quote unquote greenhouse gas. Therefore, it is indirectly, and if you breathe carbon dioxide at 0.4 parts per million, which is more or less what it is, it's not going to harm you if it's in your air. In fact, that's the way it's always been. You know, if I'm walking past a coal burning plant and they're not stopping the sulfuric acid from coming out and I breathe it, it's going to harm me personally. The supposition now is that the carbon dioxide leaves the coal plant, goes up into the upper atmosphere, contributes to a greenhouse effect, which in turn warms the planet overall. Just chemically, I just want to remind everybody, this is what I learned about carbon dioxide before global warming was all the rage. Carbon dioxide plus water in plants. Plants breathe carbon dioxide. This is happening in all the plants in all the world right now as we speak, because of God's beautiful design, that carbon dioxide mixed with the water and the light coming from the sun will produce glucose, which is a sugar that plant uses for energy to grow and heal and do all the things, produce fruit and all the beautiful things that we get to take from it. Produces glucose for the plant to grow, and oxygen and more water in the form of respiration, like sweating, like we do. So that's a very simple formulation. Everyone should be able to understand that. You know, the Earth's atmosphere contains 79% nitrogen, 20% oxygen, and then the remaining 1% of the mixture is other gases, including 0.039 carbon dioxide. So I just wanted to remind everybody what carbon dioxide is. Now, in the court case we're talking about, the best system of emissions reduction is rulemaking standard. So for years, the EPA has been regulating power plants based on the best system of emissions reductions. So what that means is that the EPA is busy at work trying to help plants reduce their emissions. And the best systems are those which are technologically available and affordable to those plants. You see, you can't tell a coal plant to reduce emissions if there is no physical way to do it. There's no technology that's even been invented yet to be able to reduce it any further. For example, here's a list of technologies that the EPA has studied and vetted as being effective in reducing emissions. And they will regulate power plants to keep their emissions below the amount that these wonderful technologies avail the energy producers to do. So as soon as a new technology is invented, perhaps we can get even greater reductions of different pollutants. But the truth is, we've achieved basically a very high standard. All the power plants in the United States are operating at the best systems of emission reduction. And that's kind of what's been motivating the executive branch of our government, who's politically motivated, very politically motivated to be seen doing something about greenhouse gas emissions. And since these coal-fired and natural gas-fired power plants have achieved such a success in reducing emissions of a lot of the other pollutants, carbon dioxide now being a pollutant, they found that what they would have to do is to actually order that these plants reduce their production. That the only way that they're going to be able to reduce carbon dioxide, they can't put filters on the smoke pipes. There's nothing to capture it, like with sulfuric acid, you can capture it before it escapes. The only way they can reduce the carbon dioxide emissions is by literally not operating at the same capacity, by reducing their capacity. And so the rules by the EPA that are in question here, based on the best system, BSER, the best system, are demanding that these energy companies, energy producers, that they actually produce less energy. And further, that they invest in what are called renewable energies, which are like windmills and solar. Now, this is the question. Traditionally, the EPA was there to reduce pollutants, and now they're saying, well, not only can we ask you to stop emitting as much as you can given the latest technology, we're telling you that you have to reduce your overall output altogether, which means that you're going to lose money, and somehow you're going to take the money that you would have invested in the profits from your business, and you're going to invest them in renewables. This all began in the Obama administration. From the Washington Post, Biden has pledged to make electricity sector carbon neutral by 2035. The Clean Power Plan, which mandated that power plants make 32% reduction in emissions below 2005 levels by 2030, would not put the nation on such a trajectory. The Clean Power Plan ran into legal trouble in 2016 as Republican attorneys general and others joined a lawsuit arguing that the Obama EPA had overstepped its authorities under the Clean Air Act. The Supreme Court halted enforcement of the plan until a lower court ruled its legality. So it does matter who our president is, because the Department of Justice under Trump was not willing to fight for the EPA and this Clean Power Plan. Instead, it took someone who wants to have us be carbon neutral by 2035, as President Biden took place in order to resurrect it. And that's why immediately when Biden resurrected it last year, all of these different states, I think it's 27 different states, and then and the power plants themselves joined together as plaintiffs against the EPA. And that's why we have this court case now. What you'll find is that the EPA and these agencies, when they are brought to task and made to account for their overreach, what we now know is overreach, when they're defending themselves, they will come up with any kind of arguments. They will take the statutes that were passed by legislature and they will stretch them as best they can. They will pick out words and they'll say that we can use those words to justify, in this case, reformatting the entire energy production in our country. So these arguments, however, concern an interpretive question that is not at issue. We have no occasion to decide whether the statutory phrase system of emission reduction refers exclusively to measures that improve the pollution performance of individual sources, such that all other actions are ineligible to qualify as the BSER. To be sure, it is pertinent to our analysis that the EPA has acted consistent with such a limitation for the first 4 decades of the statute's existence, but the only interpretive question before us, and the only one we answer, is more narrow: whether the best system of emission reduction identified by EPA in the Clean Power Plan was within the authority granted to the agency in Section 111D of the Clean Air Act. And for the reasons given, the answer is no. That's at the beginning of the summary, which I recommend you all read. I understand it's some of it's kind of boring, the ins and outs of this, but to understand the victory of it, we really need to read. There's certain choice points which I'm bringing to you tonight, like this one. It says, in a fundamental canon of statutory construction, that the words of a statute must be read in their context and with a view to their place in the overall statutory scheme. Where the statute at issue is one that confers authority upon the administrative agency, that inquiry must be shaped, at least in some measure, by the nature of the question presented, whether Congress in fact meant to confer the power the agency has asserted. So Congress did not pass a law saying that coal plants have to reduce their production and convert their businesses to wind and solar. There's no legislation. That did not happen. And that's typical of the encroachment of the administrative state, is that the legislature kind of passes the buck. They are negligent. They don't want to have to be held accountable for the kinds of things, that the dirty work that the agencies do on the ground and hassling people, from getting a fishing license to what kind of production you can do at your power plant and everything in between. So this is a separation of powers issue. And the EPA was saying, no, they gave us this power. They gave us all this power. So here we go. Here's some examples that might be familiar to you. So to get the general principle, you can see some other examples. Such cases have arisen from all corners of the administrative state. For instance, Food and Drug Administration claimed that the authority over drugs and devices included the power to regulate and even ban tobacco products. That didn't go over. We still have tobacco products. We rejected that expansive construction of the statute, concluded that Congress could not have intended to delegate such a sweeping and consequential authority in so cryptic a fashion. It's in other words saying, hey, EPA, you want to say that your best system of emissions reduction language gives you the authority to do what you're doing. But if that's the case, why didn't the legislators just say it outright? They don't need to be so cryptic about it. In this case, if the United States Congress wanted to outlaw tobacco, they would outlaw tobacco. They wouldn't say something ambiguous and then hope that the regulatory agency does what it hoped to do. And here's our favorite coming up here. In Alabama Association of Realtors versus Department of Health and Human Services, we concluded that the Centers for Disease Control and Prevention could not, under its authority, adopt measures necessary to prevent the spread of a disease and institute a nationwide eviction moratorium in response to the COVID-19 pandemic. Do you remember when the federal government was trying to stop landlords from evicting their tenants because of the COVID pandemic? And the CDC has never had such authority, and they tried to extend their authority to intervene in between the contractual relationship between a landlord and his tenant. We found the statute's language a wafer-thin reed on which to rest such a measure, given the sheer scope of the CDC's claimed authority, its unprecedented nature, and the fact that Congress had failed to extend the moratorium after previously having done so. So I guess Congress did have it in place and they didn't extend it. So the CDC couldn't act autonomously. Then you have this other decision with the EPA when they were regulating mercury and greenhouse gases in general. So there's a lot of history actually with the EPA trying to overstep its authority. And then I think there's one other good example here. We declined to uphold the EPA's claim of inherited regulatory power over a significant portion of American economy. In Gonzalez versus Oregon, we confronted the Attorney General's assertion that he could rescind the license of any physician who prescribed a controlled substance for assisted suicide, even in a state where such actions was legal. So Congress didn't give such broad and unusual authority, is basically what they're saying. So, and then COVID again, the vaccine undergo weekly medical testing at their own expense. That was an OSHA regulation that they struck down. So you can see that these agencies are constantly at work trying to control different aspects of our lives. And they always use the same rationale that it's for the greater good. Too bad for you, Mr. Businessman, or too bad for you, Mr. or Mrs. Individual trying to go on with your life. It's for the greater good. You have to comply. And that's what we at the Commoner Law Group like to educate people so that we can question the suppositions. Now, people ask me a lot of times, I'll just go right ahead and say there's a huge objection to what I'm saying or to this general policy. And that's to say, well, you know, these regulations are required and the assumption is that they will work. I mean, I guess it's true if you told every coal-fired power plant to stop burning as much coal, you're going to have fewer emissions. That is true. And so people say, what do you want, more emissions? What do you want, greenhouse gases? What do you want, global warming? What do you want, suicide, mass suicide of people because of these emissions? And that's really a red herring because to my mind, in all of these questions, the problem is that we lack the creativity and we lack the vision to come up with solutions that both solve the problem that we're supposedly facing at the same time as respecting the rights, the natural rights of individuals. And I believe that if we are creative and we're committed to both authentically solving the problem, not just propping up the cartels, but if we're authentically interested in solving a real problem and we're committed to protecting natural rights, then we can come up with a solution that honors both of those things, that accomplishes both of those things. We just need to be a little more creative. Where has the government overstepped its bounds, do you see, whether in your personal life or in industry? There's no lack of examples. And it goes unquestioned so often. That's why we're here to celebrate, because it had become completely normal for the legislature to just pass broad laws, and then hand it over to the millions of agencies who then go to work every day to enforce rules, some of which you may agree with, some of which you may not agree with. But meanwhile, the legislators, as you know, the Congress people, they just fly in their jets from place to place, campaigning all the time and saying a lot of talking points and trying to get reelected. But when you go looking at their legislation, it typically, again, just shunts the major responsibility for the detailed rulemaking off to these agencies that also have the power to enforce those rules. It's a formula for disaster, and we've been living under it for years. That the Supreme Court said, no, you can't do that. You can't use this language to justify this crazy overreach. A month ago, again, we did a special discussion on the court that ruled against the Center for Disease Control's transportation mask mandates. Struck it down because in that case, the CDC claimed that the legislation allowed them to do it. There was one word in question. It was the word sanitation, that the CDC was allowed to do sanitation and amongst a few other things in order to prevent the spread of disease. And they were saying that making people wear masks on airplanes, passengers and everyone else, was a form of sanitation. And the court really laughed at that. You know, they said, if that medical intervention is considered sanitation, then any kind of medical intervention could be considered sanitation. So they clearly struck that down. So it's a phenomenon where we, the people, need to really, first of all, hold our legislators accountable. At this point, to me, that means getting rid of all of them. There's no half measures as far as that concerned. They're pretty far gone. I'd love to just take a little little cutter, a little knife, and just cut out DC and let it go. But in the meantime, when agencies come and knocking at your door, you want to press them on which statute are they relying on? How does the rulemaking connect to the statute? And is that rulemaking at all allowing their authority to do what they say they want to do? You can model, that's what I really recommend everybody read the syllabus from the Supreme Court about this ruling, so that you understand a few basic principles of law to empower yourself to be able to do something about the things that you see as criminal or a threat, a huge threat to us, we the people. We the people are the last resort. We have to empower ourselves. The thing that you read about today, you just can't, you don't even want to look at it after a while, I just want to forget it. But I will say that there are a few distinctions in law that matter. One, apparently, and I don't know how we can overcome this, is that you have to have a damaged party. That was the case in this court ruling we're talking about here. West Virginia and a lot of the other plaintiffs had a clear damage that they were going to be told that they have to cut their production. Then you also have to have standing, so you have to pick the right court to hear your matter. And then you have to find the statute or the rule that is being broken. And then you have the cause of action to use the court system to stop them and to pay damages. And what we can do now, even in advance of someone getting harmed, is we can look into their ruling and find out on what line of code from the statute that instituted the agency in the first place. The EPA was created in 1970 by statute, and it was much smaller mandate when it began, and it just grew and grew and grew to become a cabinet level position in this day. But to understand the legislative authority upon which they feel they are allowed to even do something so crazy, something so egregious, and find where they're breaking the law, done under the auspices of some statute, but it took the agency who's doing it to interpret that statute to say, yeah, we can do that. Sure, of course we can do that. Whatever the issue is, it's got you worried. Whatever your issue is, if you want to be effective, you should find out how you can stop it. And that's why the Commoner Law Group exists, because we know that the thing that makes the difference is the law. As long as we, the people, press the law, insist that people follow the law, then we'll have a chance. But when it comes time to really getting busy and making a difference, we, the people, need to understand the laws and the rules upon which they take the authority to do these extraordinary things. And then find an avenue of remedy through the courts to stop them, just as this court case is an example of. So we're here to celebrate this victory for we the people and to learn from it, to apply it to all the millions of things that are out there. But unfortunately, we are not educated in the law. We don't know ourselves as the final resort when there's something really obviously wrong with our country. Most of us will try to write letters or spend hours and hours online watching YouTube videos. You know, you do need to educate yourself on the facts of the matter, but you need to stop educating yourself at some point on the facts, the issues of fact, and go looking at the issues of law. Okay. So there are the issues of facts. When you go to court, you have to have your issues of facts to be able to put them in evidence. But then where is the law on that? So when you go into court, those are two things you have to bring together. You have to bring the facts to marry it up with the law. And then you have a case. Okay. So we're here to motivate people and encourage people to learn enough law to be effective ultimately in court yourself. And it's not that hard. You don't have to be West Virginia. You don't have to be a wealthy power plant owner to sue the government. You can do it today. You just go down to the courthouse and you get the thing started. But you have to do the work of, again, understanding the facts and the law that applies. When you get a victory in one area, sometimes the ruling can help in a lot of other areas as well. So the law is the law, and we need everyone to stop focusing on all the dooms and glooms and horrible things. Yeah, make your list. Yeah, learn the basics the basic facts of it. But if you spend time talking about what's motivating, what's the secret mission, I did tell you tonight that it's all somehow or other related to some cartel making money and keeping profits flowing somehow. But in the end, the motivations aren't important. If you read the summary from the court case we're studying, there's nothing in there that says the EPA, and nothing about the EPA's motives. There's nothing there. At no point does the court say, "Oh, you're just trying to make money for the windmill companies, you know. Oh, you're just trying to make money for the solar panel companies. Oh, you're just trying to put the oil people out of business." There's nothing in there that refers to the motivations of the EPA. All it is this legal or not? The first line of defense of we the people is against our own government, like our own government in all those millions of agencies, whether through incompetence, through sheer corruption, or just because it's like a big beast that when it turns over, it squishes people like accidentally. For whatever reason, these agencies are out of control. And we need to use the law to push them back in a big way. And because we have this precedence from this court case, we've got a model to work with. It just takes a little research. So our job is to take the questions of fact, find the law that applies, and test it in court ourselves. So we're here to celebrate that we have, in the last couple months, we have some victories on our side, which we can use as models for our behavior. Every one of you needs to know yourself as capable and fully vested as an American to walk into the courtroom and file a complaint, walk into the court, file a complaint, and sue these people. It's a great way to bring justice. And I have a vision of millions of Americans empowered with the ability and the understanding of the law sufficiently to go into the court and shut these people down. This monster has so many tentacles. It's so enormous. Most of us are looking for some other human being to come along and do it for us. Empower yourself and go into the courtrooms and do it as it is your own self-expression, as it is your chosen battle, because you care enough to do so. We need to stop being complainers. I say that if you're complaining, then you misunderstand the whole point of our country. It's incumbent upon we the people to bring forth justice, whether we do that like they did 250 years ago by taking up arms and kicking them out. That was what they determined was the last resort for them. Or do we do it through the courtroom? So I suggest we use the courts, that we use paper and ink, so to speak, to make the difference. And we do it in a big way. Be the one to make the difference from the point of view of the law. It's only the law that has changed anything, or, as I said, when they picked up arms. So unless you're willing to go pick up arms, then your next best thing is to get into the courts. The legal solution where we, the people, empower ourselves to step up and walk into those courts and make the difference. All right, everyone. So much gratitude for people showing up. I wanted to celebrate with you. I wanted to empower you and let you know that you do have something you can do about it. The courts are there and available, and they exist for you to sue people when government, in particular, when it has overreached its authority, but it takes some work and you can do it. But check out the ruling and look for the elements of law and the elements of fact. Who's the injured party, how they established that, the way that the EPA defended its actions, and the way they tried to stretch the words to condone their new regulations, and learn. The other case about the transportation mask mandates is also very instructive. There's a lot of court cases out there that are instructive more and more. I'm crossing my fingers that this becomes the new normal, that the court systems are actually populated by judges who understand the common law, the natural rights. Let that be our prayer even, because God needs to speak to our conscience, and each and every one of us think miracles can happen, people. We don't have to envision a future that's worse than it is today. We could imagine a future that is better. And I say the more we do, the more we put our attention on the solution, the real solution, not speculations about how bad it is or the motivations or how it got to be. Let's just focus on the solution and the courts in particular. So with that, I thank you again, and I appreciate every single one of you. Come back to our next special discussion. There certainly will be good news again, and model from the victories that other people who are a little bit ahead of us and showing us the way, and we'll thank them as we mimic their solutions and their victories. Thanks again for being here. Peace, harmony, love, prosperity, happiness to all of you. All the blessings.